Welcome to this short executive knowledge lecture on topic 4, paper 6 of the SFC licensing exams. This topic covers misconduct. Now, we've done topics 1 to 3. The topic that will see the highest number of questions is topic 3, then topic 1, and then topic 2. Topic 4 is even less. So you may see 1, 2 questions from topic 4. So is it worth covering? Well, if you're sitting on 27 questions out of 40 and you need 1 more to pass, then yes, it could well be a significant topic. I will emphasize the important points to help you understand the core material you need to know to sit the exam, and as ever, a copy of the study notes you see on the screen can be downloaded from the Executive Knowledge website under Paper 6 Resources. And again, I strongly recommend that you supplement this learning with question practice, and that is provided by the Examinator.online platform, where you will find well over 230 Paper 6 practice questions. Now, if we look at what we're going to cover in topic 4, market misconduct, consequences of market misconduct, unsolicited calls, that is cold calling, and improper practices. The enforcement actions, yes, they are listed, the examples of enforcement actions in this area that the SFC have carried out, but the question or questions are going to come from topics 1 to 4. As I've said, and I must stress, this is not the trickiest topic in the paper. Nevertheless, we should pick up the salient features. Market misconduct under the Securities and Futures Ordinance. There are 6 categories of market misconduct that are listed in the box at the top of page 2. There they are: insider dealing, false trading, price rigging. Disclosure of information about prohibited transactions, disclosure of false or misleading information, inducing transactions, and that can be rumours, and out-and-out stock market manipulation. Now, the SFC considers these to be more serious than just misconduct because they bring the market, Hong Kong market, into disrepute, and they view that very seriously. Now, if you are suspected or if the SFC wish to prosecute you for market misconduct, they can take you down the civil route on the left or the criminal route, but not both. There is no double jeopardy. So if you are prosecuted down civil route under civil law, you cannot be prosecuted under criminal law and vice versa. Now, if you're taken down the civil route, your case will be heard by the Market Misconduct Tribunal, and the level of proof will be balance of probabilities. If you're taken down the criminal route, your case will be heard by a court of law, and the level of proof will be beyond reasonable doubt. Now, there are 1 or 2 other features with regard to the prosecution of market misconduct at the top of page 3. SFC is the power to prosecute minor cases summarily in a magistrate's court. Parts 13 and 14 replicate each other. Part 13 covers civil law, part 14 criminal law. And as I've said, there's no double jeopardy, and choice of route can depend on issue of evidence, as criminal case needs higher standard of proof. Part 14 offences are pure criminal, and 3 of them are listed there. Now we have the definitions of the 6 categories of market misconduct. Insider dealing, and the definitions are listed for dealing, tipping off, inside information, and connected persons, and we are alerted to defences against the charge of insider dealing. False trading is where you want to give the impression of active trading in a stock to influence the market. For example, you may be looking to issue a convertible bond, and the uptake in such an instrument will depend on the trading activity of the underlying security, and there has been cases where people have done this artificially. And false trading, affects the whole market. It's seen as market misconduct. It can be affected through a wash trade, which is selling a security and buying it straight back, or match orders where you put out a bunch of buys, a bunch of sells, but you don't actually carry them through. Price rigging is considered to be a subset of false trading, and it's specifically to do with, not surprisingly, rigging the price, either getting the price up through fictitious or artificial transactions, suppressing the price, or keeping the price steady. Stock market manipulation is just out and out manipulating the market by entering into two or more transactions having the effect of increasing, reducing, maintaining, stabilizing security prices. Now, in the box is a couple of important points that can pop up in the exam. False trading, price rigging, and stock market manipulation, as defined, they cover transactions carried out in Hong Kong or elsewhere. That is, anywhere in the world with regard to Hong Kong traded stocks, and in Hong Kong with regard to any market traded investments, be they New York, London, but if it occurs in Hong Kong, then the legislation applies. We then have definitions of disclosure information about prohibited transactions, where you're fanning the flames, you are letting people know that certain transactions which are prohibited are being carried out. And 1.7 looks at the disclosure of false or misleading information inducing transactions, just out and out incorrect information being put out, being dishonest. The rumour mill, you'll find there are virtually no rumours in Hong Kong now, because if a rumour started to circulate, the SFC would trace its source and prosecute. The international aspects I've covered in the box on the previous page. Conduct not constituting market misconduct. Well, this is to do with the safe harbour rules. And for our exam, there is only one safe harbour rule to be aware of, and that's the price stabilising rules, which makes what otherwise would be market misconduct allowable for a period of time. And that is where the issuing company and or the underwriter is allowed to support the price, artificially support the price of a new listing for a period of time. It's actually 30 days, but we don't need to know that for this exam. And they are allowed to do this where a listing doesn't achieve the offer price. It falls below. And so for this 30-day period, issuer, the underwriter can go into the market, buy the stock, support the price, but you cannot take it beyond the offer price. And the reason that the SFC allow this is because it is in the public interest. Okay, let's leave the 6 categories and move on and look at what the consequences are of market misconduct. What happens to you if you're found guilty of market misconduct? It depends whether your case has been heard under civil or under criminal law. If it's heard under civil law, you will be in front of the Market Misconduct Tribunal. And there's some administrative points covering that tribunal at the top of 2.1. I want to go down the bullet points and look at the orders that may be made by the tribunal against those that have been found to have committed market misconduct. Now remember, this is under civil law, so there'll be no imprisonment. The disqualification order can disqualify someone for up to 5 years from holding office as director, liquidator, receiver, or taking part in any management of a corporation. The cold shoulder order will prohibit someone from investing or trading in Hong Kong markets for up to 5 years. Prohibition of further market misconduct, well, that's obvious. You just can no longer do what you were doing that was considered misconduct. Payment of profits made or loss avoided plus compound interest goes to the government, and reasonable costs that have been incurred by the government and the SFC will also have to be paid. And finally, disciplinary referral orders. The Market Misconduct Tribunal can recommend that a professional body takes disciplinary action against the person who is a member of that body. Section 2.2 looks at criminal sanctions imposed by the court. So this is under criminal law, and you can see that sanctions are 10 years imprisonment, 10 million Hong Kong dollar fine on conviction and indictment, or 3 years imprisonment and 1 million fine on summary conviction. Now, people have often said, well, What's the difference between conviction, indictment, or summary conviction? It's the scale of the case. So I've been told smaller cases in front of a magistrate, district court, where the judge or magistrate will give the verdict and the sentence. That is summary conviction. Judge and jury, bigger cases, are conviction and indictment. Private civil actions can occur on top of either civil and criminal routes. And this is where someone brings up a private action against someone committing market misconduct to sue for their own personal financial loss. But we're told at the end of that first sub-bullet point that damages will only be paid if it's fair, just, and reasonable, and I have seen that once examined. We move on to section 3 and the world of cold calling or unsolicited calls. Now, an unsolicited call is just that. Someone has not invited you to call, and it's usually by phone or in person. And it's an offence to engage in such a call where you're trying to sell a financial product. And the 3 cases are listed there under the second bullet point. Now, the reason for prohibiting such calls is to protect the investing public from recklessly giving personal details, etc. And the points are covered there. Now, important set of individuals are those that are exempt from the prohibition. In other words, you can cold call these parties and it's okay. You're not committing an offence. They are exempt. Existing clients, licensed persons, registered institutions, that's all intermediaries. PIs, professional investors. Solicitors, accountants acting in their professional capacity, and moneylenders. So if I was setting an exam question for topic 4, that would be attractive. There are 6 bullet points. I could play around with those. Then after those points, we're told the prohibition on unsolicited calls does not apply to an agreement to buy or sell securities from someone who already owns those securities. The idea is that they already know enough about the securities. We then have one point at the bottom that is linked to the diagram at the bottom of page 8. A person who enters into an agreement as a result of such a call may rescind the agreement, may get out of the agreement, maybe you've given credit card details, by giving written notice within 28 days of entering into the agreement or within 7 days of finding out about the contravention, whichever is earlier. Now, many people say, okay, but what does that really mean? It means that for a 28-day period, you have the right to rescind the agreement. During that 28-day period, once you discover it was an unsolicited illegal cold call, you've got 7 days to get out of that agreement. So that 7-day period is within the 28 days. Once you get to day 28 and beyond, you have lost the right, irrespective of the 7 days. So if you discovered on day 27, then you've got to get out by day 28. Now, improper practices. Improper practices are unethical market malpractices, but they're not as serious as market misconduct. So they're not seen in the same light because they're not influencing the whole market. The whole market is really macro. These practices are micro. It's individuals. Now, they may be illegal. It could be unethical, and you can be prosecuted, but not the civil criminal route under market misconduct. What are they? Boiler room activities, that is the use of high pressure sales tactics, usually to sell something that is fraudulent. Churning, that's buying and selling investments in a portfolio to generate sales commissions. Corporate misgovernance is the opposite of good corporate governance. You are running the corporate to the disadvantage of some of the stakeholders. Front running is where you go in and buy or sell, you transact before you've given your clients the opportunity to trade. So maybe on the release of new information, you must wait until your clients trade. Rat trading is trading to the disadvantage of your clients, an American term. Unsuitability, that's where you recommend or sell a product to a client that is unsuitable for that client. And unauthorized trades are exactly that. The client has not authorized you to conduct that trade. These are known as improper practices. Now, how will they be examined? A favorite for the examiner is that they will ask you which of the following are market misconduct, and they will throw in one or more improper trading practices. So an improper practice is not market misconduct, and vice versa. The other way they can examine this is to home in on one of them, one of the improper practices, and ask you, what does it mean? And they will give you relevant options. Enforcement actions, yes, they're there, but they are unlikely to be examined. Okay, that is the end of topic 4. As I said, unlikely to be many questions at all, but I would be aware of it. And as ever, I would practice questions. There isn't as many questions on topic 4 as the others, understandably, and you will find them on Examinator.online.